Good evening and welcome to Courts Today by LiveLaw. I am Urvashi Chauhan, and in this video we cover some important legal developments. From Supreme Court's decision to form a bench for Justice Yashwant Varma's plea to the rejection of appeals by Kal Airways in the SpiceJet dispute. We also bring updates on the Dharmasthala burial case, the CBI probe into builder bank Nexus in NCR, a plea against Vijay Shah, and court's remarks on protecting lawyers' careers. Plus, the top court calls for a transparent inspection system for law colleges. Watch till the end and make sure to subscribe and hit the bell icon. The Supreme Court today said that it will constitute a bench to hear the petition filed by Justice Yashwant Varma, who has challenged the report of an in-house inquiry committee that had indicted him in the cash at residence controversy. The case was mentioned before a bench led by Chief Justice of India B.R. Gavai along with Justices K. Vinod Chandran and Joy Mallya Bagchi. Senior advocates Kapil Sibal, Mukul Rohtagi, Rakesh Dwivedi, Siddharth Luthra and Siddharth Agarwal appeared for Justice Varma. They requested the court to urgently constitute a separate bench citing serious constitutional issues. The CJI responded by stating that he may not be the appropriate person to deal with the matter but assured the lawyers that the bench would be constituted soon. Justice Varma, currently a judge of the Allahabad High Court, has also challenged a recommendation made by the then Chief Justice of India Sanjeev Khanna to the President and the Prime Minister calling for impeachment proceedings against him. The controversy, as you know, began on 14th March this year when a fire broke out at an outhouse of Justice Varma's official Delhi residence. During the firefighting operation, a large sum of cash was allegedly discovered by fire brigade personnel. Following this, a three-judge in-house committee was set up by the then CJI. Justice Varma was sent back to the Allahabad High Court and his judicial work was withdrawn. In his petition, Justice Varma has alleged that the committee acted unfairly. He claims he was not informed about the inquiry procedure, was denied a fair opportunity to respond to evidence, and that crucial exculpatory evidence like CCTV footage was ignored. He also alleges that the burden of proof was wrongly shifted onto him and he was denied a personal hearing. The committee, on the other hand, had concluded that Justice Varma's conduct after the fire was unnatural and drew adverse inferences. After examining 55 witnesses, including Justice Varma and his daughter, and reviewing electronic evidence, it found that the cash was stored in premises under his or his family's control and that he failed to give a plausible explanation. The petition filed by Justice Varma now seeks to set aside the committee's findings and the consequential recommendation for impeachment. The Apex Court today dismissed the plea filed by Kal Airways and the former promoter of SpiceJet, Kal Maran, seeking 1,323 crores in damages from the airline. A bench of Justices P.S. Narasimha and A.S. Chandrukar upheld the Delhi High Court's May 2025 decision, which had rejected the appeal on grounds of delay and suppression of facts. This dispute dates back to 2015 when Kal Maran and Kal Airways sold their 58.46% stake in SpiceJet to co-founder Ajay Singh for a nominal 2 rupees as part of a revival plan during the airline's financial crisis. They also paid 679 crores to SpiceJet for convertible warrants and preference shares. However, in 2017, Maran and Kal Airways filed a suit alleging breach of the agreement, accusing SpiceJet of failing to issue the agreed shares. The matter went into arbitration. In 2018, a tribunal of 3 retired Supreme Court judges rejected the damage claim of 1,323 crores, but directed SpiceJet and Ajay Singh to refund 579 crores along with interest. Maran also sought restoration of his shareholdings in SpiceJet, but that was denied. Both sides challenged the arbitral award in the Delhi High Court. In July 2023, a single judge upheld the tribunal's decision and directed a refund of 270 crores plus interest to Kal Airways and Maran. This was later remanded for reconsideration by a division bench in 2024. Maran and Kal Airways had challenged that remand before the Supreme Court, but their plea was dismissed in July 2024. Then again, in May 2025, the division bench of Delhi High Court dismissed Maran's further appeal, citing delay and suppression of material facts. And today, the Supreme Court upheld that decision too, effectively putting an end to the damages claim. The legal battle between the two parties, let me tell you, has now spanned nearly a decade. Congress leader Dr. Jaya Thakur has approached the Supreme Court seeking removal of BJP Minister Kunwar Vijay Shah from his ministerial position over controversial remarks made by him regarding Colonel Sophia Qureshi. As you know, Colonel Qureshi had become the public face of Operation Sindoor after she led press briefings on the Indian Air Force's strikes on terrorist sites in Pakistan. The controversy arose after Vijay Shah said at an event referring to Colonel Qureshi's role that those people, referring to terrorists who had wiped out the Sindoor of our sisters in the Pahalgam terror attack, we avenged these people by sending their sister to destroy them, implying that the Indian response was delivered by sending a Muslim woman officer to take revenge on Pakistan-based terrorists. In her petition, Dr. Thakur argues that Shah's remarks violate the oath of office taken under Article 164(3) and the third schedule, Form 5 of the Constitution, which mandates ministers to uphold the sovereignty, integrity, and constitutional values of India and to act without fear or favor. The petition alleges that the remarks fuel communal division, particularly by associating a Muslim officer with the terrorists and thereby endanger national unity. The petition also cites the Supreme Court's judgment in Tehseen Poonawalla, which condemned hate speech and communal violence as threats to constitutional morality and the rule of law. She thus prays for removal of Kunwar Vijay Shah from his ministerial post. I must also tell you here that a bench of Justices Suryakant and Dibankar Datta is already seized of related petitions filed by Shah. On 19th May, the Supreme Court directed a special investigation team of 3 IPS officers from outside MP to probe the FIR filed against him. The court also stayed his arrest, which continues as of the last hearing on 28th May. You must already be aware of the Dharmasthala burial case, where a sensational allegation made by a sanitation worker in Karnataka shocked the nation. He claimed that between 1995 and 2014, he was ordered to secretly bury the bodies of women and children in and around Dharmasthala village, a site known for its prominent Sri Manjunath Swami temple. His statement led to registration of an FIR and formation of a special investigation team by the Karnataka government, triggering serious questions about possible mass burials and institutional involvement. While the case is under investigation, the Supreme Court today refused to entertain a plea challenging an ex parte gag order, which restrained over 390 media platforms from publishing or broadcasting any allegedly defamatory content related to the Dharmasthala temple in connection with this ongoing case. The ex parte gag order was issued by a Bengaluru civil court on 18th July on a suit filed by Harshendra Kumar D, who is brother of Virendra Hegde, who is the Dharmadhikari of Sri Manjunath Swami Temple, Dharmasthala. The court barred the publication, circulation, or broadcasting of any alleged defamatory content against the temple, the plaintiff, or his family across all media platforms, including YouTube, social media, and print. The order also included a sweeping John Doe direction asking for deletion or de-indexing of the specified 8,842 URLs from the internet. Challenging this, a plea was filed by a YouTube channel named Third Eye before the Supreme Court, challenging the gag order and saying that it was obtained through calculated abuse of judicial process and material misrepresentation. It claims that the plaintiffs falsely stated that there were no allegations against them in the FIR linked to the Dharmasthala burial case, despite the FIR naming institutions and individuals associated with the temple. The petitioner also argued that such a sweeping order amounts to a direct attack on press freedom, especially when the matter is under state-level investigation involving serious allegations. It was also argued that the gag order was passed within just 3 hours, directing the takedown of over 9,000 links, including videos and articles, without giving them a chance to be heard. The matter was mentioned today before a bench led by Chief Justice of India B.R. Gavai, with Justices K. Vinod Chandran and Joy Mallya Bagchi. However, the Supreme Court declined to interfere and advised the petitioner to first approach the High Court for relief. In a significant development in the ongoing Builder Bank Nexus case, the Supreme Court has allowed the Central Bureau of Investigation to register 22 regular cases based on its interim findings into massive real estate loan irregularities in the National Capital Region. To help you recall, this case revolves around how builders secured thousands of crores from banks using subvention schemes, where home buyer takes the loan in their name, but the builder agrees to pay the EMIs until possession of the flat is given. Eventually, when the builders here defaulted payments, banks began recovering the amounts from the buyers despite no flat ever being handed over. Over 1,200 home buyers filed a petition and approached the Supreme Court regarding this. The CBI had earlier been tasked with conducting 7 preliminary inquiries into the alleged collusion between real estate developers and banks that resulted in home buyers being burdened with EMIs without getting possession of their flats. While 6 of these inquiries have been completed, the court has given 6 more weeks to complete the remaining 1 involving projects outside NCR. A bench of Justices Suryakant and N. Koteshwar Singh today acknowledged the seriousness of the allegations, appreciating CBI's efforts in examining over 1,000 people, reviewing voluminous records, and physically inspecting 58 project sites. Based on the findings, the court permitted registration of 22 FIRs to take the probe forward. Meanwhile, the court also took serious note of reports that Gurugram courts had been issuing coercive orders against home buyers despite Supreme Court's stay on such actions. The court has now directed the District and Sessions Judge Gurugram to conduct a fact-finding inquiry and file a report within 10 days on why such coercive measures were passed despite Supreme Court orders. The bench also examined an application regarding Samman Capital, which was formerly India Bulls Housing Finance, where it was alleged that anti-social elements were sent to home buyers to force recoveries. Senior advocate Mukul Rohtagi, appearing for the company, denied the claims and said that only staff had visited the buyers. Well, the court has exempted company's MD and other officials from further personal appearances, but has agreed to keep a close watch on the matter. The bench also considered a detailed note from amicus curiae Rajiv Jain, which the court termed an eye-opener, and directed that relevant portions be shared with the CBI and ASG Aishwarya Bhati for further action. The Supreme Court today held that lawyers should not be castigated for small mistakes, as that may affect their career detrimentally. The bench of CJI B.R. Gawai and Justices K. Vinod Chandran and Joy Male Bagchi was hearing the issue arising from a split verdict by another bench of the Supreme Court. This case began when the top court discovered that a special leave petition was filed by an advocate on record to bypass an earlier direction which had asked the petitioner to surrender. The petition was allegedly based on distorted facts, and the court saw this as a serious lapse in professional duty. Initially, the bench comprising Justices Bela Trivedi and Satish Chandra Sharma heard the matter. Both agreed that the lawyers had not upheld the honor of the court. But when it came to the punishment, both the judges disagreed. Justice Trivedi wanted strict action, to suspend the AOR for 1 month and fine the assisting advocate 1 lakh rupees. She felt that the legal profession must be held to high standards, and this kind of conduct could not be brushed aside. But Justice Sharma took a different view. He pointed out that the lawyers had promptly offered an unconditional apology, showed genuine remorse, and had an otherwise unblemished record. He believed that the punishment would be too harsh. In view of the split decision, the matter had to be placed before the CJI's bench for appropriate orders. Well, the present bench has concurred with the view expressed by Justice S.C. Sharma, observing that the majesty of law lies not in punishing someone but in forgiving them for their mistakes. The bench noted that Justice Sharma's opinion had taken into account the complete and unconditional apology tendered by both advocates, who had expressed genuine remorse and assured that such conduct would not be repeated in the future. And lastly, the Supreme Court has asked Bar Council of India to propose an independent, impartial and transparent mechanism for conducting annual or periodic inspections of law colleges and universities. This came while hearing a petition challenging a Bombay High Court judgment that upheld BCI's authority to inspect Nathibai Damodar Thackeray Women's University Law School. The petitioner had questioned BCI's power, arguing that the Advocate Act does not explicitly permit such inspections and that legal education is governed by the Maharashtra Public University Act of 2016. However, the High Court had ruled that legal education rules of 2008 framed by the BCI are valid. It held that BCI's inspection powers are supported by sections 7(1) and 49(1) of the Advocates Act, which empower it to maintain and monitor standards of legal education. It also relied on Supreme Court's judgment in BCI versus Bonifoy Law College, which emphasized BCI's central role in regulating legal education. The High Court clarified that even if there is a conflict between the state law, that is the 2016 Act, and the Central Advocates Act, the latter would prevail as it is a parliamentary law and a special statute governing legal education. Well, the matter is now before the Supreme Court, which has sought suggestions from BCI on setting up a proper inspection framework.